Greetings, dear colleagues, candidates, and the public. Today, on the 18th January 2025, the advisory group of experts met in full composition to interview the candidate for the position of judge of the CCU, Balatska Olha Romanivna. In particular, AGA members are in attendance. AGA Secretary, Madam Maureen O'Connor, AGA members Vasil Shakun, Yaroslav Romanyuk, Mr. Alice Zalar, and me, AGE Chair, Oksana Vasilchenko. Also, 5 deputy heads, AGE members, Vitaly Makinchuk, Volodymyr Kuzmenko, Marek Zubik, and Mr. Richard Barrett present. I'd like to know that we are working in a shelter, so in the event of an air raid alert, the interviews will be continued without interruptions. I'd like to also remind you that the interview is recorded and broadcast live on the AGE web resources on the CCU website. Therefore, I remind the AGE members and the candidate that using sensitive data and restricted information and the data that refer to your personal life must be limited while on the live broadcast. Should there be a need to discuss such questions, the AGA will pause the broadcast for that period. We are ready to start, so I give the floor to AGA Secretary Madam Maureen O'Connor to briefly introduce the candidate and reiterate the rules of procedure for the interview.
Thank you, Madam Chair. Good morning, all. Dear colleagues, and to everyone who is watching, and to the candidate before us. As the chair has just said, the advisory group of experts will now interview the candidate, Olha Balatska. I hereby recall that the interview is an opportunity that is provided and is mandatory in assessing the candidates within the assessment of their compliance with the criterion of high moral qualities. The time allocated for one interview is approximately 1 hour, and the time limit for answering the questions is up to 3 minutes. As always, we ask each candidate to be concise and provide answers that are clear, unambiguous, and to the point. At the end of the interview, the candidate may make a brief closing statement of up to 5 minutes. I would also point out that in the course of processing materials about the candidate, the AGE sent her questions to provide written explanations, so the candidate had an opportunity to prepare for today's interview and to provide answers. So now here is the candidate for the position of judge of the Constitutional Court of Ukraine, Olha Balatska, whom the Selection Commission under the President of Ukraine has admitted to the competitive selection. In July 2024, Mrs. Balatska was appointed a judge of the Rivne City Court of the Rivne region. She is also an associate professor of the Department of Civil Law Disciplines at the National University of Ostrach Academy. Before 2023, she had been practicing law. In 2018, Ms. Balatska defended her dissertation entitled Participation of the Defendant in Implementing the Principle of Guaranteeing the Right to Defend Legal and Organizational Aspects, and is a doctor of philosophy. Ms. Balatska, if you wish to add something to this introduction, please do so now for up to 2 or 3 minutes.
Greetings. Thank you so much for introducing me. That's enough.
Start with the questions, and I'd like to remind you that the purpose of the questioning today, and I'd like to remind you and then everyone who is listening, is to dispel reasonable doubt that we have after we have investigated, we've received your answers, and there are areas that we need clarification, and again, to dispel the reasonable doubt that our investigations has created. So I'm going to ask you, for confirmation, you were appointed as a judge of the Rivne City Court in 2000 by the President of Ukraine, July 5th, 2024. Have you started working as a judge?
Thank you so much for the question, Madam Marine. Yes, on the 4th of July, the order was issued to appoint me as the judge of the Rivne City Court in the Rivne region. I am the judge who's exercising the justice, but I haven't started fulfilling my duties in the court yet. Exercising justice on case consideration, I mean.
Are not, have not taken the bench and heard cases and performed the duties of a judge as of yet, correct?
By decree of the President of Ukraine as of the 4th of July, I was appointed as a judge of the Rivne City Court. In accordance to the law of Ukraine on the judiciary and the status of the judge, the procedure for gaining the duties of the judge presupposes that the judge has to undergo a special training and also, of course, take an oath. And after that, they are recognized as such who has already taken up on their duty. So I have taken my oath on the 11th of December 2024 in order to complete the procedure of gaining the status of the judge.
When you were taking part in the selection of the position of judge of the Rivne City Court in the Rivne region, did you alert the High Qualification Commission of Judges of Ukraine of your intention to take a research leave after having been appointed a judge and you have not heard cases or acted as a judge? I know you're appointed as a judge, but actual courtroom activity has not taken place. So did you share with the High Qualification Commission of Judges your intent to take a leave when you became, if you had been appointed the judge?
Прошу уточнити. Дякую.
Thank you for your question. Please, I will ask you to clarify. Are you now referring already to my research leave?
You are on a research leave right now, is that correct?
Так.
Yes, correct.
You are on that leave to write your dissertation, correct?
Yes, correct. Right now, I'm on the research leave to complete my dissertation, doctorate dissertation.
So you asked and were granted a leave of absence from your job as a judge for the Rivne City Court. Is that accurate?
I took the research leave after I was already credited in the staff of the judges. I have undergone the training for judges for the first instance court organized by Lviv Regional Department. And I didn't have the powers, I wasn't authorized to consider cases yet. I was at work every day. I was doing some analytical work. I prepared the proposals for the judicial administration, for court administration, providing replies. So every day, being as part of staff of judges, I fulfilled my duties as the judge. But since I still didn't have powers to consider cases, and I understood that when I start doing that, and in October, I already had 80% of readiness of my thesis. So I expressed this intent to take my research leave and to exercise my right to take it. And this was as of 12th of November.
All right, my question to you is, did you inform the High Qualification Commission of Judges of Ukraine that you would be taking a research leave while they were considering you, before they selected you for this position? Did you share that with them?
I did not alert the High Qualification Commission of Judges since I was already in the staff of judges, and this was after the decree of the president has been issued. So I informed the court administration and the head, the chair of the Rivnensky court.
In your opinion, did you provide full information to the High Qualification Commission of Judges of Ukraine?
On account of what information to the High Qualification Commission of Judges? Please clarify.
Intended to take a leave of your duties of a judge to finish your dissertation.
Я не повідомляла.
I did not inform the High Qualification Commission of Judges.
Then that you provided full information to the High Council or High Qualification Commission of Judges. You didn't share with them that you would be immediately taking a leave from your judicial duties when they were considering you for this job.
Вища кваліфікаційна
High Qualification Commission, they considered my candidacy for this position in the spring, in 2024, winter and spring. So I have completed the stage of gaining the status of the judge into in the High Qualification Commission. All the procedures that I have undergone in the commission were completed. And then I had the interview in the High Council of Justice, and only after that the decree was issued. And so the intent to take the research leave, I decided to exercise this right in October 2024.
Let me move on then. Do you think it's fair to your colleagues that not having taken up your duties as a judge and making application for research leave and not having been administering justice for 10 months since your appointment, and considering the number of vacancies and the caseload of the judiciary, do you think taking a leave at this point is fair to the colleagues?
Дякую.
Thank you for your question. Madam Marine, I am in the staff of the court as of August 2024, so it's not 10 months. Also, I did not have powers yet to consider cases because I didn't take an oath of the judge. I only took it in December. Apart from that, I understand indeed the caseload, but I have weighed and I know the caseload of my colleagues whom I work with, because as of September I was at work every day. In our Rivnensky court we have 25 judges, and 22 of them are judges who have powers, who are granted with the powers and who exercise their powers.
You took your, according to our records, and please tell me if this is correct, you took your oath of office on the 11th of December 2024. But on November 8th, 2024, you applied for a research leave for the period between November 12th, 2024 to May 11th, 2025. Is that accurate?
Пані Марін, я
Madam Marine, I would like to clarify. I have applied for the research leave in the beginning of November, and I took an oath on the 11th of December.
That's what I said.
Тобто не після
But not after I took an oath, I took the leave, but before.
I understand that. I guess the questions we have, did you disclose to the people who would select you for being a judge that you were going to immediately take a leave and for the period of November of 24 to May of 25? Do you think that was something you should have told them?
Так, пані Марін, я
Yes, Madam Maureen, I should have informed them because given the caseload of my colleagues, and we had the general meetings of the judges, and we have agreed on these matters. So the colleagues supported my decision, since if I started considering cases and then would take the research leave later, this could cause a breach of case considerations, and then my cases would have to be redistributed among other colleagues. So I decided to focus now. I do not state, I mean, it doesn't mean that I will be in this research leave until the beginning of May, because I envisage that I will complete my dissertation sooner, because I actually have already prepared in accordance with all the formal requirements. I got all the publications and so on.
Currently earning a salary as a judge, is that true?
так,
Yes, yes, yes.
Salary of a judge, but you are not, but you are on leave, so you are not hearing cases. Is that a fair statement?
так.
Yes.
All right. And is it possible for you to finish your dissertation, as other judges have done, while working and finishing their dissertation during their spare time and on weekends?
Для того, щоб
To do the quality dissertation research, in order to start fulfilling my duties as a judge in full, I think that the scientific work would distract me from it, and then I won't be able to complete my dissertation that I have been working as of 2020. For 5 years, I've been working on it. So given this, I made that decision.
I'm going to switch the focus now to questions about the practice of law. Now, according to the decision of the Bar Council of the Rivne region, number I-28 of the 16th of September 2016, you were granted a certificate entitling you to practice law. Is that correct?
так.
All right.
Yes.
Did you actually practice law?
Так, здесь.
Yes, I did.
And you were a member of the Ukrainian National Bar Association since 2016? That's also a fair statement?
Так.
Yes.
Continuously, without interruption.
Ні, ні, були
No, I did have breaks. I seized my right to do this attorney activity for the period of the special preparation in the National School of Judges for the training. This was as of August 2018. Hold on a second, I will give you the exact information. August 2018, as of because as of August 2018, I have undergone special preparation, special training as the candidate for the position of the judge in the National School of Judges up until the February the 1st, 2020.
Did you reflect that in the Ukrainian National Bar Association's, did you indicate that in your declarations, the accuracy of the dates and the time from your admission in 2016 till the present? Did you accurately reflect in your declarations your status as a member of the Ukrainian National Bar Association? Or were there some things that were omitted?
I omitted, and I did not specify my membership in the National Association of Attorneys of Ukraine. And because of that, I sent a notification in the personal account of the NACP. And since this was not intentional, I did not try to hide my membership in this official organization. Also, there was no income from this activity. And for the period of filling in the declaration for the first time, when I was submitting the declaration for 2016, I tried to, there were trainings undergoing as well, but more attention was paid on how to reflect the source of origin of income. But since I had never been a member of any political organizations or civil society organizations, I had this faulty impression that this was not a membership because I did not submit any application to become a member of the National Bar Association, and besides there is now ongoing case regarding constitutionality of that, but I do not refuse to take responsibility for that, because having looked through the explanations of the NACP, I realized that I had to declare this membership, so I took respective measures.
Okay, now you practiced law, and under what terms did you provide attorney services?
I will divide a bit in terms of periods of my activity as the attorney. I got my license certificate in 2016. And also I worked at the main place of work as the legal advisor. And when I was working as the legal advisor in 2016 and in 2017, I had more time to dedicate to my attorney's activities during the initial years, until I starting my path as a candidate for the position of the judge of the first instance. So I did practice law, and initially I provided pro bono services, completely pro bono. The agreement on legal aid provision set out the possibility to provide these services both on a paid basis and pro bono. And later on, as I have already mentioned, the attorney's license was suspended. I renewed it in 2020. Since 2019, when the competition for the position of the judge was suspended, the key focus of my professional work was educational work. I taught, and it was my main place of work, and teaching was my main place of work, and I was the head of the faculty as well. Since 2020, I practiced law as an independent attorney. It happened rarely, so it was up to 5 cases per year when I could find time during summer periods or during vacation periods, and when really I was addressed by people from socially vulnerable categories of the population and to whom I could provide legal aid. So legal aid was provided pro bono.
Okay, so our records indicate that throughout this time period, that you had approximately 40 cases that you were involved with, according to the Register of Court Decisions, between 2016 and 2023. Is that an accurate number? And are you saying then that you were not paid for any of that activity? It was all pro bono?
I divided that in 2016-2017 it was on a paid basis as well, among other things. And I submitted tax declarations as a self-employed person, according to which I declared income from my attorney's activities, expenses from attorney's activities. And I paid the single social contribution as well.
But after that,
А після
after that
цього
period,
уже
Yes, and after that, since 2020, yes, it was rights advocacy activity.
це було
It was kind of legal aid that I provided as a socially aimed aid for vulnerable categories of the population. And these were only individuals from among retired persons, service members.
and that started, you said, in 2020?
так, так.
Yes.
I want to ask you about one particular case that has come to our attention. According to the United Register of Court Decisions, the operative part of the decision, there was a decision by the Slavuta City District Court. Are you familiar with the case? On December
Так, я
2,
Yes, yes.
and that case, the order from the judge said that cost of the legal assistance provided by you in the amount of, I guess it's 5,000 hryvnias, were to be recovered from the losing party, the Aland Limited Liability Company. And there's a similar order in the operative part of the decision made by the Ostra District Court in Rivne. Okay, why do these court decisions award you money and you say that you did not, you were doing pro bono work?
Yes, these were only two cases like that. I'm grateful to the AGE for paying attention to this. The situation under those cases and with my clients to whom I provided my professional legal aid was the following. In one of these cases, there was the client who was a retired person to whom I provided legal aid, and with respect to him, there was enforcement proceeding by the notary, according to which I've described the details to you. Unlawfully, his pension was collected. And under another cases, also my client repaid the credit, but according to the enforcement proceeding, there was collected the specific amount of funds from his salary, and it was unlawful. And due to that, we filed a claim in order to stop this enforcement under these proceedings by the notary. And together with the claim, we filed a preliminary approximate estimate of expenses on of court expenses, which included a court fee that was paid and which also included expected expenses on legal aid.
Attorney fees. You let the court know what the attorney
Так,
fees were going to be.
так.
And the court awarded you those attorney fees.
Так.
And the losing party, I had to pay those attorney fees.
Так,
That's
так.
what they,
Yes, 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 yes.
so did you receive that money?
Ні, я
No, I did not receive those funds.
е,
because my clients did not have the opportunity to pay for these expenses on professional legal aid. So they did not have this financial possibility to pay for my services as the attorney. And once the court adopted the decision, they were not performed voluntarily. These decisions came into force, and one of the clients did not have any intention to continue this collection because they did not believe that they could collect anything from that financial institution. And the other client wanted to submit this court decision to the enforcement service, but I do not know about further fate of this case. And they did not pay my expenses for professional legal aid.
So it wasn't your client that had to pay it, it was the party
Інша сторона.
for whom the judge, ordered to pay it. Okay,
Так.
not your client. And are you telling me they didn't pay it? The losing party refused to pay the 5,000 hryvnias?
Так.
Yes.
There was a means to enforce that. You could have enforced that, correct?
Yes, there were means to turn to the enforcement service and to collect that through force.
And when did you decide that you were not going to be paid for this case?
When I decided that I will not receive a payment for this case.
Didn't start out as a pro bono case. You intended to receive attorney fees through an order of the court if you were successful, if your client was successful.
The case started as a pro bono case. It was envisioned by the agreement on legal aid provision that there was a possibility of honorarium that was so-called success honorarium in case the court fully satisfies the claim and the funds are collected from the other party.
And just to be clear, for all of the time that you practiced law, except when you were an advisor early on, these 40 cases, you received no money. They were all pro bono. They were all for people who could not afford to pay you.
Miss Maureen, I'm sorry, but I've calculated since 2020 until 2023. In total, I had 16 cases. 40 cases, that is the number of cases since 2016.
But did you earn a fee, a legal fee, from 2020 to 2023?
Ні.
Okay.
Ні.
No, no.
From before 2020, did you earn a legal fee from the cases that you took on?
Until 2020, there were instances when I received honorarium, yes.
And you report that those honorarium as income, pay taxes, there's no problem
Так.
with that?
Так.
Okay,
Yes.
thank you.
Дякую вам.
Thank you. Miss Olha, I have several questions to you. One of the components of integrity which we are clarifying in order to establish whether the candidate complies with the criteria for the judge of the Constitutional Court of Ukraine, is the legality of the source of origin of property and correspondence of the lifestyle of the candidate and their family members with the declared income. So that's why I have several property-related questions to you. In September of 2023, you bought an apartment in Lviv. First of all, the AGE paid attention to the fact that the estimated price is obviously undervalued in the sale and purchase agreement, but you explained that it was not your problem, that it was the assessment by the seller. So I have another question about the source of origin of property. When you were participating in the interview with the HQCJ, initially you explained that you used your own funds to buy the apartment. Then, after a break in the session of the HQCJ, you changed your explanation and you said that based on oral deed of gift from your husband's father, that is, from your father-in-law. And while providing explanations to the AGE regarding this issue, you confirmed that funds were provided by your father-in-law, and you also provided the written deed of gift regarding these funds. So I have the following question: why is there such discrepancy, such inconsistency in your explanations regarding this important issue for the assessment of accuracy of your income used to buy the apartment in Lviv? Thank you, Yaroslav, for this question. First of all, I would like to clarify that I did not receive any questions about undervalued price. And since you voiced it, I would like to say that the price was not undervalued. Okay, let's focus on the source of origin of funds. We are not reproaching you regarding this undervalued price. You bought it for the price that was offered. We understand that. Let's discuss source of origin of funds. Source of origin of funds. I do not see any inconsistency regarding the confirmation of the source of origin of funds, since I mentioned it with the HQCJ and I mentioned it during the interview with the HCJ, and I also provided written explanations to the High Council of Justice regarding the source of origin of funds used to buy this apartment. And these sources included funds received as my income and income of my husband, as well as funds gifted by the father of my husband, parents of my husband. Again, in the HQCJ, you explained that it was the oral deed of gift, but you provided a written document to us. The HQCJ did not clarify this question with me. And during the interview with the HQCJ, this issue was not raised for discussion. Still, you said that it was oral deed of gift without any documental confirmation. During the interview with HQCJ, one of the members of the HQCJ mentioned and asked whether the written deed of gift was concluded or not. I knew that I did not have this deed of gift with me. My husband was serving with the armed forces of Ukraine. I did not ask him and his father whether they had any written agreement concluded, so I did not explain that in detail at the HQCJ. I provided supporting documents to the HQCJ to confirm the sources of origin of these funds. I provided tax declarations on entrepreneurial activities by the husband's father, which confirmed the legality of these funds. Okay, clear. In such case, can you please explain about the source of origin of funds of the father, because he gifted 1,850,000 hryvnias. That's about $50,000. What is the source of origin of these funds? From entrepreneurial activities. These funds could be accumulated as savings by the father from his entrepreneurial activities. During the interview with the HQCJ, you provided a similar explanation and you confirmed that with documents providing specific amounts with a breakdown by years. However, once we calculated all of these amounts, still we see that these funds were not enough to make such a gift. Can you please explain the situation in detail?
From the tax returns that were submitted by my husband's father as an individual entrepreneur, I'm not going to now tell all these amounts because I have already provided them. I was also additionally providing the the income from the entrepreneurial activity disaggregated by months and the amount my father managed to save up. My husband's parents, they work really hard, and they're all their lives they have been working really hard to help their children. Irina Romanivna, when we asked you, stating that this money was not enough, and you have provided us additional explanations, stating that in 2013 your father got the income in the amount of 422,000 hryvnias, which is the amount of income accrued based on the progressive principle over the year. But it means that 83,000 hryvnias cannot be the additional income you are referring to, but are instead included in the amount recorded in the State Register of Individual Taxpayers. How would you explain this? In 2013, my father managed to save up more anyway because they had savings with his wife previous. So maybe they did save up this amount from the income in 2013 that I have specified, because as of 2001, parents and my husband, they have conducted their entrepreneurial activity, and I have additionally explained that no, we understand your reply. We only have 1 hour for the interview with you, so we understand that they could save up, but you cannot confirm this. I did confirm it with the tax declarations. I see. Thank you. The next question refers to the apartment in Ostrog city. In 2019, your husband's mother donated to your husband apartment in the city of Ostrog. So again, the sources of money, your explanations being inconcise, because you first explained that the money to purchase this apartment were obtained as income in the year of the purchase and the savings in previous years. Then you have explained that this was money that were donated to you and your husband for your wedding. And then you have explained that this money was gifted to you for the wedding by your husband's parents from the income obtained by your husband from the entrepreneurial activity. So why is such inconsistency in your explanations, and what is the actual situation? Thank you, Yaroslav Mikhailovich. That is actually true. Just like I answered the 6th round of answers, I don't think I was inconsistent. It's just that part of the tax returns, I didn't have some part of the tax returns. I didn't have some paper confirmation. And because of that, I have specified in the first answers to the questions of advisory group of experts, I said that this money was income of parents and also of my husband's and I. And that's the real situation. My husband started the entrepreneurial activity in 2003. He lived with his parents, and they together conducted entrepreneurial activity. We got married in 2005. After we got married, we lived together with his parents, and correspondingly, the money, the entrepreneurial activity, so partially from entrepreneurial activity carried out by the parents of your husband, and partially these were funds donated to you as a gift to your wedding, right? This was the money that was donated to the wedding. This was the income from entrepreneurial activity. I see. Next question. In your explanations, you specified that between 2001 and 2005, your husband's father earned an income of 340,000 hryvnias from his business. Not even income, but proceeds from the sale of the goods at that period of time. And the proceeds is not the net income, because you have to pay rent from that amount, you have to pay rent for the premises, to pay wage to the employees who help you exercising the entrepreneurial activity, and also you have to purchase the new batch of goods. So this is not net income. Yaroslav Mikhailovich, please clarify which period do you refer to? In your explanations, you specify that between 2001 and 2005, your husband's father earned an income of 340,000 hryvnias. But in accordance with the provided documents, and we speak about 2004 and 2005, this was not income. Yes, these were the proceeds from the sale of goods. Yes, these are different things. I agree. I agree these are different things. But during that period of time, we purchased the apartment that cost 19,000 hryvnias. In our calculations, we cannot have this amount in total. It just doesn't look like it that this could be possible to purchase such apartment. So, okay. So if the money for the purchase of this apartment was obtained by means of the entrepreneurial activity by your husband, and were also donated to you to this wedding, why was this apartment registered for the mother of your husband? Given that the sources of this money was the entrepreneurial activity conducted by my husband together with his parents, and that's why you registered for his mother. Yes, that's why his parents made this decision that it should be registered. I see. Given the source. So, okay, I'm not. I haven't objected this because I realized that. Okay, we see, and we understand. We understand what you're saying. Next question will refer to the land plot. The according to the deed of gift as of 24th of December 2019, your husband's mother donated to your husband a land plot. And in 2010, your husband's mother became the owner of this land plot on the year when it was purchased. So there is the logical question, the sources of money to acquire this land in 2010. And again, we see the inconsistency in your explanations. First, you said that apart from the money obtained by your husband's parents from the entrepreneurial activity, you're saying that there were also your and your husband's money as your shared income in 2008 to 2010. And then you said that this will only money earned by your husband in 2006 2012 as business income. So why such inconsistency, Olga Romanivna? Okay, you purchased. I don't see inconsistency in my explanations. I have indicated that this land plot was purchased with income of my husband's parents' money and my husband's and mine money. I see. As for the cafe shop, According to the deed of gift of the 15th of July 2020, your husband's father donated a cafe and coffee shop with a total area of 232 square meters to your husband. What sources of money did your husband's father have to acquire this real property in 2000? From the documents you have provided and the information the AGE possesses from their own sources, your husband's mother income as of 1993 till 1998 was 8 point almost 5,000 hryvnias, and additionally unemployment benefits it's 451 hryvnias. That's in 1999 and 2000. And how, with such income, was it possible to save up 15,000 hryvnias to purchase this cafe shop? I have indicated and explained that the shop that was purchased in 2000, my husband's parents purchased with money they have been saving during all their lives, starting with their labor activity in 1974 until 2000. Also, their parents were helping to my husband's parents. I mean, the parents of their parents. And according to the information that is in state register of individual taxpayers, there is no information about that income. And in order to obtain the confirmation of the income, I have only provided the copy of the certificate from the pension case of the husband's mother, but the specified by you, Yaroslav Mikhailovich, amount 8,400 hryvnias. But my husband's father also worked in that same organization. He also got salary even higher from the words of my husband's father. They did apply, but this requires additional time to obtain these certificates. But they did contact them, and we already have taken measures. Also, my husband's father contacted the enterprise where he used to work as the guard in order to get the certificate of confirmation of income. And in accordance with the information from the labor book, they have been saving up all their lives. They also had land plots where they had agriculture activity, they had some cattle and so on, and they're still doing it. And this enabled them to save up during all their lives in order to be able to purchase this shop. I see. Thank you. Thank you for your question. Now I pass the floor to Maureen O'Connor. Let's continue.
Your attention to a vehicle that your husband owns, and my understanding is the vehicle was acquired in a damaged condition and repaired, and that accounts for the low purchase price of this vehicle. Is that accurate? Mm-hmm. Okay. What damage did the car have?
The damage was the lights, the cooling system, the radiator, and there were some mechanical damage. And this car couldn't go on its own. So my husband repaired this vehicle all by himself. And he purchased this car in order to use it for the entrepreneurial activity, for agriculture with his parents. So they were looking for a cheap car just to satisfy these needs.
Do you know what the source of this light damage and the other damage to the car was? Why was it damaged?
From the words of my husband, this was in the RTA, but we do not have the confirmation on the road traffic accident. So the seller did not provide us these documents, and we did not request it from him at that time.
Because according to the information from open sources, this vehicle has never been involved in any traffic accidents in the European Union. So the explanation that this car was in damaged condition due to an accident cannot be proven.
No, it wasn't damaged abroad. It was damaged by the previous user in Ukraine. But whether or not this RTA was registered, no information I have. And my husband didn't provide me this information.
Was imported to Ukraine from the Republic of Poland. And it was first registered in Ukraine to your husband. He was the first Ukrainian to be registered to this vehicle. And as I said, there's no indication either in Ukraine or Poland that this car was damaged via, because of an accident. Do you have any response? And I ask you this, okay, here's the basis for our reasonable doubt. The purchase price for this car was about 7 times lower than what that car, a 5-year-old vehicle, average price would have been for it. It would have been between 15 and 20,000 euros. And some information would say even with the nature of damages that you described, it would be between that range. So the purchase price is at least 7 times lower than the market price, and that is a question that we have, and we have no proof. There's no record that this car was ever damaged, and your husband was the first titled owner of the car in Ukraine. You can see how that would give rise to doubt on our part. Could you not?
Yes, I understand, Madam O'Connor, why you have the reasonable doubt, given that this car, well, since I know that those people who transported this car to the territory of Ukraine, they were using it, and these were the acquaintances of my husband, and these damage were made by one of those men, but I have no confirmation.
I would like to move on. We just have a few minutes left here, and I want to talk about your academic pursuits. And we have, gone back and forth with a series of questions and answers to you recently about your research articles under the title of The Formation and Development of Concepts of Access to Court and Historical and Legal Context, which you published in 2024 in the Science Rise Judicial Science Journal. And based on our investigation and review, some of the paragraphs in this research article are identical to the paragraphs written by other authors, in particular Andrusenko and Horodovenko. However, when you use these paragraphs in your article, there is no attribution. They are identical wording, and you can see on the screen the areas that are on one side is the article that we compared it to, the other side is your article, and you can see the similarities and the number of paragraphs that are identical. So how do you explain that there's no attribution to the source that you received this information from?
Thank you, Madam Marine. Thank you for such work done. And I have provided the explanations to the advisory group of experts, stating that the subject of research in this article was the formation and development of access to justice. The direction of this article is general theoretical research, and also this research was carried out in different spheres of knowledge, both the legal, philosophical, sciences, historical. Given that, in my publication, there was information that was generally well known, both in the legal profession, in the law profession, and in other spheres of knowledge. The paragraphs that are given as identical in the comparative table were caused due to the fact that the authors I did reference, they have systematized in full the historical stages of formation of access to justice.
These were Dmytro Andrusenko, for example, Madam Ovcharenko, Viktor Hrodovenko, Olesya Kozakevich, and all of the positions from their academic papers are given in the list of references and literature sources used. And my publication also contained respective references.
Let's move on to November of 23. You delivered a report at the 10th International Applied Research Conference. The availability of a court established by law, removing obstacles to access to justice. And there were also a number, you were also a member of the editorial board for the collection at the conference. Accurate? Okay. However, paragraphs 2 and 4 of your report contain no references whatsoever to being and they're almost a complete reproduction of an abstract from the report of the Ukrainian Parliament Commissioner for Human Rights on the observance and protection of human and civil rights and freedom of Ukraine in 2022. Do you agree that the inclusion of these abstracts without attribution in your report could be viewed as plagiarism?
With respect to this, I also provided explanations regarding the abstract of the report. This textual coincidence in my abstract and the speech by the Ukrainian Parliament Commissioner are related in the list of references, I contained this report of the Ukrainian Parliament Commissioner. I also made reference in one of the paragraphs, and I did not make a reference in another paragraph. And in my explanations, I said that these paragraphs are interconnected. And in the report of the Ukrainian Parliament Commissioner reflected problems regarding the judiciary reform that is ongoing, the lack of judges, etc. So this information is well known in the legal profession. It's well known, and I made a reference to this report of the Ukrainian Parliament Commissioner, but I agree that there are recommendations of the Ministry of Education and Science, and I should have been more thorough and I should have made references in both paragraphs. And I've already taken measures regarding this. And you know, back then I was also at the position of the head of the faculty, and because of organizational work, maybe I did not pay enough attention to my abstract. I had no intention to borrow the information from this report, since I included this reference in the list of references. But yes, I'm not refusing that I'm responsible, and I have taken measures in order to have the reference after the 2 paragraphs, and these changes have already been included there.
You made those corrections after we brought it to your attention that they should have been included in your original. Is that not true?
Yes, yes.
And you can see, obviously, why we would have reasonable doubt when it comes to these paragraphs and how they were identical to the work of the abstract. And then, in order to respond to our inquiries, you immediately tried to correct it and did correct it. So you agree that they should have been, from what I heard in your answer, you agree that they should have been identified originally, as we've indicated. I think that's all the questions I have. I wonder if any of my colleagues have questions.
Шановні колеги,
Dear colleagues, Ms. Hanna, Mr. Alish, do you have any questions? I have a question. Vasil, please. Can you please tell me who was your academic supervisor when you were writing your candidate's dissertation and where you defended it? My academic supervisor was Lukyachenko Yevhen, and I defended in the Bar Academy of Ukraine. Okay, clear. And what about now? What's the topic of your dissertation? Access to justice. And who is your academic consultant? And where do you do that? Access to justice as a guarantee of fair trial in Ukraine. The topic was adopted by the Academic Council of Ostrog Academy in December of 2020. The academic consultant was Popelushko Vasil. Popelushko Vasil has been determined as my academic consultant. Unfortunately, he died, and subsequently I engaged in my academic works on my own. As far as I understand, you have not completed your dissertation. 80% is ready. Okay, clear. Dear colleagues, since there are no more questions to the candidate, Olha, you have up to 5 minutes to say final concluding remarks. Please, the floor is yours. Thank you. First of all, I would like to say glory to Ukraine. And I would like to express my gratitude to the Ukrainian people and to the armed forces for having the possibility to take part in this responsible competition for such a position. Also, my motivation has not changed. That is, not to be aside as a lawyer, as a citizen of Ukraine, in the processes of state making that are happening in Ukraine. Also, I would like to express my sincere gratitude to God, to my relatives, to my colleagues, to my students who believe in me more probably than I believe in myself. And also I would like to express my sincere gratitude to and to assure the AGE of my respect for a very detailed check, for your time that you have dedicated, and for thorough analysis that is really valuable. Thank you so much. Thank you, Olha, for your answers. Dear colleagues, dear public, at this point I declare the interview with the candidate Balatska Olga Romanivna as closed.